Hey guys, it's Kathy. I hope you're doing well, especially all you in Texas and anyone else who got hit by the hurricane. I read that there was like 2.4 million people out of power in Texas, but Fozzy's in my chat saying he got power back. He lost power. He was powerless. It was, I'm sure, like Little House in the Prairie at his house for a bit today. They're probably rubbing sticks together, wet sticks. And, a lot of the comments for me yesterday. Yeah, you're right. You would not go down in the basement during a hurricane. All I thought about was the wind. The water never even crossed my mind. But Donald, this guy today is maybe I'm wrong. Maybe he's just sleepy or sick. Maybe he has a mental or physical illness and he's not baked at all. You guys can tell me if I'm lying, if he's not baked. Um yeah, unfortunately, that's true. That's true. Okay, yep, Kelly didn't even get touched. The She didn't even get cooled down, like, with all that wind, you would expect the temperatures to go down a little bit. Nope, she's still baking. I know I'm baking, and I'm in Pennsylvania. I'm not even down south, and I am, whew, hot today. Whoa, look who's here. All right, I need to show you guys something real quick, though, before we start. Okay, ready? Hold on. Look at this. So I stumbled on this today. This is a Valorant tournament, right? I think stage 2, week 4, day 1. It doesn't even start for 3 days. All right. Oh, you can't see because that stupid thing is there. Hold on. Let me get it out of the way. So the part I wanted you to see, you can't see. Nope, you can't see it. But there are literally 838 people in the waiting room waiting for this. It does not start for 3 days on YouTube, and they're already in the waiting room waiting for this. So remember that day I said I was going live, but it was like an hour away, and everybody went into the chat room here and was like, "Oh, what am I supposed to do for an hour?" You got lucky, guys. You got lucky because these people are still there right now waiting for this. Hold on. I should check it out, see how many people are literally there right now. Hold on, I'm gonna look for it. BCT. Are we doing the W4D1? I found it. There are, oh, it's down, guys. They must have got tired of waiting. There were 800 people in there, and now there's only 200. Losers. No, I don't mean the people waiting. I mean, the poor YouTube channel lost all those viewers. Don't worry, they'll be back, guys. Oh, wait, I have to keep that over there. They will be back as soon as that tournament starts. All right. Oh, no. Chris was in the hospital a week ago. But he's more energetic than before, guys. Hi, AC. AC had a great live today, guys. I'm telling you, AC had a great live today. Go check it out. All right. Whew, I don't know where to start. We have so much. Let's just go with the guy baked. Let's go with the guy. Maybe he's not baked. Maybe I won't tell you who it is, and then you'll be looking at the wrong guy the whole time. Because I was.
And we'll go ahead and take your case. That's Christopher Green, cause number 4A0265384. That's actually off the 2:30 calendar.
Thanks, Edward.
Mr. Green, if you want to go ahead and unmute your microphone. There we go. Good afternoon, Mr. Green.
And this matter is on for bench warrant quash, but the parties do have a resolution.
All right. But I suspect you would like me to quash the warrant as well.
Please, Your Honor.
Okay. It's always good to have the orders ahead of time if you want that done. Let me see if I can find that. All right. I've added that. So I will sign the order unless the city has any objection. I will sign the order recalling the warrant.
No objection.
Thank you, Your Honor.
All objections.
All right. With regard to the resolution of the case, I see that there's a statement of dependent on plea of guilty. Is that how we're proceeding?
Yes, Your Honor.
Would you like to make your record?
Mr. Green, please state your full name.
Christopher Green.
And you are 25, correct?
Yes.
And the highest level of education you completed was high school?
Yes.
Do you understand the elements of assault in the fourth degree that the city would have to prove in order to find you guilty at trial?
Yes.
Yes.
Do you understand that when you plead guilty, you are giving up the following rights? The right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. The right to remain silent before and during trial. The right to refuse to testify against yourself. The right at trial to hear and question the witnesses who would testify against you. The right at trial to testify and have witnesses testify for you who could be made to appear at no expense to you. The right to be presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And the right to appeal a finding of guilt after a trial.
I would rather be on probation.
All right, Ms. Barber, I'm having a hard time.
I would rather be on probation to
All right, Ms. Barber.
Am I still having to see?
Mr. Green, I'm going to stop this right now because I've been concerned already that Mr. Green was either distracted or not able to follow what's happening on the Zoom hearing. Is there a reason we can't set this over to an in-person calendar?
Your Honor, and I'm sorry to interrupt you, but I don't know that defense has necessarily the correct offer. This is not the city's offer. The city is offering to amend, so I don't think we should proceed today.
All right. Mr. Green, is there any reason that you could not come to court for this hearing?
He should not
I'd like
drive
to do
drunk.
this in person.
I have a lot. I have stuff.
I'm sorry?
I have a lot of stuff.
Okay, well, I'm going to set this over and we'll try to accommodate your
Stuff.
Calendar. This is a first appearance. Okay. I'm going to add that document in as well. Give me just a moment.
How many people watching are jealous right now?
All right. Nope, that's the wrong one.
I don't think he realizes anything right now. He is baked.
There we go.
Funny you should mention that, Donald, because I have a case coming up with the best hair.
Is it a motion to continue, Your Honors, trying to enter?
Today is his first day appearing before the court after a warrant. I don't think we need a motion to continue.
Your Honor, I could put in a
motion.
notice of hearing.
Yeah.
I've got a pretrial order in there, order on pretrial, or an order on release. So I think that might be the cleanest. Well, or order setting court dates is probably good enough. Let's do that. There we go. Notice of hearing. Got it. All right. All right. I'm going to set this to pretrial on so we're pretty full for a little while, Mr.
It gets
Green.
better. Don't worry,
I'm
it
going to have
gets
you
better.
come in on August 22nd at 2:30. That's a Thursday afternoon. Any reason you wouldn't be able to make it to court on that date?
I work.
Can you take some time off from work? What days do you work?
I haven't made that much money.
Okay. What days do you work?
This month. The 20th.
I'm sorry?
The 20th.
The 20th? Okay. And what days are you going to be working in August?
I have to check.
Go ahead. I'll give you time to check.
What time is this trial?
It's a hearing at 2:30 in the afternoon on Thursday, August 22nd.
Okay.
In Boston. That's okay? Okay. So I'm going to set that date. That's in person and you must appear. Okay? Between now and then, I want you to meet with your attorney to be sure you understand what's happening, because I won't take a plea if you don't understand what's happening. Okay?
Okay.
Can Miss Barber sign this order on your behalf? Can your attorney sign for you on this order? Put an X on the signature line, saying that you're going to appear on the 22nd of August.
Yes.
Okay, thank you. Ms. Barber, if you can do that, that will conclude this matter. Mr. Green, we'll see you on August 22nd at 2:30 at the Bothell Municipal Court.
There was one part in there that's interesting. If you watch her, she always talks that slow. Gosh, look at that guy's eyes right now. Stop. She always talks that slow. She always is very deliberate. And when anybody has a question or something, she explains it as kind and thoroughly as possible. But when Tracy Greenwood said, you know, do we need a motion for continuance? Her answer like stopped me short because she was like, it's his first appearance, so we don't need that. I've never heard her talk that badly before, and you probably didn't even notice it, but that was harsh for her. I've never heard her talk that harshly before. She was mad at that guy. Simple Auto Solutions, thank you from Colorado. Okay, I got a video in the members only area that I put there today that I'm not going to ever release outside of the members area because I don't know, there's all kind of trigger warnings on it. But it's a great judge. She's great. She's really great. But it's in there and in there it'll stay. Okay. Now let's go to a car that gets arrested. Since Simple Auto Solutions put that up, we'll go to the car that got arrested.
All right, we're all set.
You're all.
There we go.
Hits me.
Hi there. Can you state your name, please? Your name?
Mikhail Torich.
All right, Mr. Torich, you're here for warrants for your arrest. 3 cases. 2024 CM 12136, 12139, and 12159. The first case is 2 counts of contributing to the delinquency of a minor. The second one is criminal damage and disorderly conduct. And the third one is criminal trespass. On those charges, you failed to appear on all those cases for your arraignment, and you had warrants for your arrest. So what I done is I scheduled you for a court date tomorrow. You'll remain you remain in custody on the same bond, which is 500, 500, and 2,000. But your court date is for tomorrow, so I'll have you have an attorney.
500 and 2,000. It was the total of the bond.
Correct. 3,000 total. Correct.
Okay.
And then you'll see your attorney tomorrow. I've got you an appointed attorney. You'll talk to your attorney tomorrow and see how to handle these cases. I'm entering not guilty pleas for now, so you can have your attorney will help you out.
So how soon can I see my attorney? Today or tomorrow?
Tomorrow.
So for today, I'm staying here in the facility for tonight, or am I out, or do I need to pay the bond?
No, you can pay the bond if you want, or you just see your attorney tomorrow at the case pretrial conference, and then we make a determination if you can be released after tomorrow.
Well, but what would you recommend? It looks like I'm the only one here. Can I just get out of this court, take care of my car, which is still about to be sold by LaForge Towing Law? They're about to auction my car. I want to release my car at least. You know, and be at court at 8 a.m.
Is it Russian?
Anyways, I had a court tomorrow at 9 a.m., right?
Correct. 9 o'clock tomorrow, and that's why we're holding you, is because you failed to appear for your last court date.
Of course, which was on Wednesday. I had not even a cell phone, right?
Okay, so that's why we're holding you in custody on the warrants. So you have a $3,000 bond if you want to get released, or you'll just see your attorney and come to court tomorrow, and we'll make a determination after that.
Where does Legal Fiction live? Is that what the accent is?
Well, I'd love to be released because $3,000 can be bonded by my relative if that's needed. I have even a credit card with me to bond me out, right? On the same time, I need to see my attorney or to talk to attorney, ideally today before tomorrow 8 a.m. Makes sense, right?
Yes.
And I must appear in court. And what I learned in law school, if I'm innocent, the bond will be returned to me, to the credit card, right?
Correct.
So why don't we just, why do I have to sit here completely alone with the sheriff together, like sleeping, if I can take care of, let's say, $3,000 bonds, right?
Yeah, you can post the bond.
Sounds Russian.
I can pay the bond. I'll be in court tomorrow anyways because I have to rescue my car. It was a great idea of police precinct to arrest the car, which has my documents inside, computers, cell phones, everything. It's still at LaForge. They're about to sell it. They already put in paperwork to sell it. They're already auctioning my Mercedes-Benz.
Okay.
So I'm ready to pay the bond. If it's $3,000, I do have a credit card with me or
Alright.
in fine.
So if you want to post the bond, then talk to the detention staff about that. They'll be able to help you.
Well, how are they gonna help me? There's one guy and me, one
If-
sheriff and me.
Well, yeah, they'll talk to
Okay.
you about that. Yeah. So you'll have to ask them. I'm not them. Yeah. All right.
Fantastic.
Otherwise, either way, we'll see you tomorrow in court.
In any ways, yes. You will
Okay.
see me tomorrow at court, which opens at 8 and court starts at 9 at Gila County First Floor, right?
Correct. Thank you.
Work.
Have a good day, sir.
Guys, that seriously sounds Russian. All right, hold on. I'm going to play the beginning again to get his name. Ready?
All right, we're all set.
He's trying to get him to be quiet.
And then there we go.
Hit me.
Hi there. Can you state your name, please?
Huh?
Your name?
Mikhail Torich.
Mikhail.
Mr. Torich, you're here for warrants.
Mikhail. I think that's Russian. Mikhail is Russian, right? All right, I'm dying on that hill. Yep. I'm always wrong though, so I'm good. I'm good with that. Okay, so it was rude of the police to arrest his car like that. Let's go softly into this courtroom. We're gonna play one clip from this courtroom that's not too bad, and then we'll get to the pro se guy later. And this girl has great hair. Here we go.
Yes.
So this is the hell courtroom that's just so dark and dark and dark. But I don't know if you can see it when they move because it's so dark, like the tops of their heads are all like so bright. But this girl's hair right here and here catches the light and the light makes it look great. It might be in the next case we see it better. It is. It is. In the next case we see it better. Very shiny. All right. All right. Stop paying attention to hair. We're looking at court, guys.
Good morning. Please raise your right hand to be sworn. Do you swear or affirm under the pains and penalties of perjury, the testimony that you provide to this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. And are you able to hear me okay?
Can you hear her okay? No, but that's not your problem. I can't hear anybody. Well, you need to be able to hear her.
Ms. Schweinsker, would you like to retrieve the hearing device?
Okay.
We'll see if that works.
The clean because no one's ever used it before hearing device that he's going to shove into his ear. No.
All right, Mr. Hale, is that any better? Okay, I could tell immediately based upon your reaction. Okay. All right, please tell me your full name.
Carl Milton Hale Jr.
Thank you. The court shows that the defendant appears in person and also with Attorney Kelly Schweinsker. The state of Indiana appears by DPA Anna Rich. I show that we are set for a change in plea hearing. I further show that a plea agreement has been filed on the defendant's behalf. Schweinsker, is that what we're doing today?
Yes, Judge.
Mr. Hale, according to the plea agreement, you will be pleading guilty to count 2 domestic batteries and Class A misdemeanor. Is that correct?
That's correct.
Sir, according to the terms of the plea agreement, you will be sentenced to time served, judgment of conviction will be entered, and you will pay the mandatory court costs only. In exchange for your plea, counts 1 and 3 will be dismissed. Your cash bond of $500 will be applied towards your outstanding court costs. And the jail credit is from April 7th, 2024 to May 28th, 2024. Mr. Hale, is that your plea agreement?
Yes.
Sir, in looking further through your written plea agreement, I see that there are initials that appear in the numbered paragraphs in the defendant's right section. There's also a signature at the end of the plea agreement.
Are those your initials and is that your signature?
Yes, it is.
Before you initialed those paragraphs and signed that document, did you read through it carefully?
Yes, it did.
Did you also review this plea agreement with your attorney, Ms. Schweinster?
Yes, it did.
Do you believe that you understood the rights in the defendant's rights section?
Yes, I did.
And do you understand the plea agreement itself?
Yes, I do.
Mr. Hale, do you understand that when you plead guilty that you give up your right to have a trial by jury?
Yes, I do.
Do you understand that by pleading guilty that you are giving up your right to remain silent?
Yes, I do.
Do you understand that by pleading guilty that you are giving up your right to confront your accusers?
Yes, I do.
And do you understand that by pleading guilty that you are waiving or giving up all of the other rights that are mentioned in the advisement of rights section of your plea agreement?
Yes, I do.
Sir, before you
High
appeared in court
security.
this morning, did you consume any alcohol, drugs, or medications?
Nothing I don't take every day.
Okay, so you take some medications regularly.
I take all kinds of medications regularly.
Okay, is there anything about those medications that affect your ability to understand these proceedings?
Now, I have a serious brain injury. I don't even understand what's going on, but yeah, I do.
But do you understand what's going on?
No, I understand all this stuff.
Okay, so Mr. Hale, you seem to be tracking fairly well with the questions that I'm asking. So you said that you had a brain injury at some point in time?
Yes, ma'am.
Okay. So Mr. Hale, that certainly is serious. And I understand that generally legal proceedings can be fairly confusing. But so far, are you following along with all of the questions that I'm asking you?
Yes, I guess so.
Okay, is there anything that you need me to go over with you again?
No, the attorney explained it all to me pretty good.
Okay.
It's either, anyway.
Mr. Hale, if you have any questions throughout these proceedings, feel free to let me know and I'll do my best to answer those questions for you. But I certainly am gathering from all of the information so far that you seem to understand what's going on so far yet this morning. Would that be fair to say?
Yeah, I understand.
All right.
The only question I've ever had was possession of a weapon. That was it.
Okay. And I don't see the
This is the part here that got me. This is the part here that made me say, oh man, this one is
charges noting anything about a weapon. I don't know anything about the other allegations, Mr. Hale, but there's nothing about the charge to which you are pleading guilty that would indicate to me that there was a weapon.
His concern is the fact that he will lose his right.
Oh, gotcha.
That's the part that bothers me after several years in the military. Other than that, I don't have a problem with anything going on.
Okay, and Mr. Hale, that is a requirement under Indiana law. And I'm sure that Ms. Schweizer explained to you that there is an ability to restore that right after a period of time.
I'm an old man, so I don't think I got to worry about that a heck of a lot.
Well, Mr. Hale, I didn't want
thank
to
you
say
so
that.
much. Entry required. Thank you.
I'm saying,
Sweden.
Okay, all right, you said it. But Mr. Hale, that is a
Mr. and
requirement under
Mrs.
Indiana law, and there's nothing that Ms. Schweinster can do about that. There's nothing that I can do about that.
let me ask you a question. Is that true in a different state? In my interpretation, Arizona, where I came from, a misdemeanor did not take away a gun right, period.
I would say that's probably generally true about a misdemeanor. However, domestic battery is different. And I don't know if it's different in the state of Indiana, but I can tell you that that might be the exception in Indiana regarding losing your firearms rights in a misdemeanor case.
Well, the only question I had is the fact that the gun had absolutely nothing to do with what
And I understand that.
the fact there was a gun in the house and now I've lost my gun rights. Well, I almost gave my life for everybody's gun rights, and that's the objection I have. Otherwise, I would just say guilty and have a nice day.
Mr. Hale, your concern is understandable. And again, there is a mechanism under Indiana law that after a period of time, you can have your firearms rights restored. Your point is well taken, that based upon your age, that that may or may not be a reality for you. I don't know that. I certainly
Harsh.
don't mean
Whoa.
to dismiss the importance of your service, and I am a staunch believer in gun rights, and I certainly recognize that. However, under Indiana law,
I understand.
okay, so
I'm not special,
okay, so you,
only to my mom.
oh, fair enough. So Mr. Hill, I understand you don't like it, but you understand that that is the status of Indiana law. Would that be fair to say?
That's correct.
All right. Mr. Hale, you are a citizen of the United States, correct?
Yes, I am.
Sir, has anybody forced or threatened you into pleading guilty?
No.
Are you pleading guilty because it is your choice to do so?
Yes.
Has anybody promised you anything to get you to plead guilty other than what is in the plea agreement?
No.
Do you understand that if I accept your plea agreement, that I will sentence you according to the terms of your plea agreement?
I have one question and then I'll be done.
That's fine.
My understanding, if I leave the state, I don't have to be on probation. Is that correct or incorrect?
This plea agreement does not call for you to be on probation at all.
Okay,
So you will be sentenced to time served at the time of sentencing and you'll be done.
we're all set. I'm a happy camper.
Okay. Do you understand?
Happy camper?
I am a happy camper, Mr. Hill.
Do you understand that your plea of guilty may cause harsher sentences for any crimes that you might commit in the future?
I'll take a chance.
Let's take a chance at not committing any crimes in the future. How about that?
Okay,
All right. Again, sir, you are pleading guilty to domestic battery as a Class A misdemeanor, which is punishable by up to 1 year of incarceration and a maximum fine of $5,000. And again, Mr. Hale, at the time of your sentencing, I will make a domestic violence determination, and that means that you will lose your right to possess firearms and ammunition. I don't know if this applies for you. I don't want to assume one way or another, but if you have minor children, you could have restrictions in parenting time with those minor children.
I don't know.
All right, Mr. Hale, have you reviewed the charge that was filed against you with Ms. Schweinsker? The one that you're pleading guilty to today? And has she explained to you what the state is required to prove in order to convict you?
Yes,
Ms. Schweinsker, does your client waive the formal reading of the charging information and statute?
He does, Your Honor.
Mr. Hale, do you understand what the state is required to prove in order to convict you of this offense?
yes,
Do you also understand the possible penalty that you face?
yes,
And with everything that we have discussed, do you still want to plead guilty pursuant to your plea agreement?
based on what you told me, certainly.
All right, factual basis, Ms. Schweinsker.
Thank you. Mr. Hale, I'm gonna take you back to April 7th of
Thank
this
you
year.
so much,
On
enter
that date,
required.
were you in Elkhart County?
I didn't see the Karen Reed yet. I know it was a train wreck. I didn't see what the latest motion was, but I'm going to check it out.
In the state of Indiana.
Yes, there was.
And on that date, do you admit that you and your wife, Lisa Hale, were at your home and the two of you got into an argument, correct?
Yes,
And you admit that that argument became physical, correct?
yes,
Now, you explained to me that because of being in the military and your background, that you have this rule that if someone enters your space, you're going to react, and that that's what you did with your wife, and that you did touch her in an angry or rude manner because she entered your space, correct?
correct.
And you admit guilt to domestic battery, is that correct?
Yes,
Nothing further on a factual basis.
Does the state have any questions on the factual basis?
Nothing from the state.
The court will find that the defendant has tendered a knowing and voluntary plea based upon the factual basis. Counsel, do we need to set this out for victim notification?
Yes, we were not able to complete victim notification.
All right, so we will have to come back for sentencing. I need to find my calendar, not for a lengthy period of time. It looks like the next date that I would have available would be on July 22nd at 8:30. Is that acceptable to the state?
It is.
oh, The state. Oh, I'm the state.
No, she is the state.
All right, so the court will reset this for sentencing to July 22nd, 2024 at 8:30 a.m. I'm not going to do any reports. No reports. All right, thank you.
Okay, so that was the first one from this courtroom. Well, we got a pro se coming up. And so this is the second, third, whatever hearing they had for this pro se, and I didn't get the one that was last week. Last week must have been fireworks, guys, fireworks. You'll see why I say that. But we got a pro se that learns. They do learn after a bit. But I'm not going to play that yet. We'll get there. Let's just work on a PR bond first. How about that? Let's work on a PR bond in Michigan.
Good morning, sir. What's your name, please?
Giovanni Carson.
Thank you. Give me one moment.
Good morning. How you doing today?
I'm doing good. How about yourself?
Can't complain. Blessed, very in God's will. You know what I'm saying?
All right. Well, let's see if we can get you out of there. You got a couple of traffic tickets.
I'm getting out of
You
here.
got a couple of traffic. Sir.
Hey, stop acting like you know me, man. I'm not no felon. I only got 3 tickets.
All right. We're not cutting me off today, all right? I want to get you out of there, but you keep telling me what I'm gonna do. You'll be staying there a few more days. You got a couple of tickets. You got a couple of tickets we're going to deal with first, where you missed some court dates. When you miss those dates, the judge issued an arrest warrant for you. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will provide one for you. First ticket you've got is P 1513043 with a charge of disorderly conduct. Next ticket is P 1581421, charge of disorderly conduct. These are both misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or a $500 fine. I'm going to set aside the arrest warrants, enter a not guilty plea on your behalf, give you a personal bond. Your next court date is a pretrial August 6th in front of Judge Jones here in 36 District Court.
Yes, sir. Yes, sir. No problem. What did I get arrested for, though? They never heard me my rights. I was assaulted. I was sexual harassment. You feel me? We gotta go ahead and get to the point. You can't just swoop me up off the street and just think I got tickets. It's gonna go like that. So if it's gonna go like that, you feel me? You're gonna be a part of this case, my sir. Come on now. I was very assaulted and I was treated like I was a felon. Come on now, sexual harassment. All this. So we're gonna play the game how it's played. We're gonna play the game how it's played. Come on now.
Okay, sir. All right. So here's what we're gonna do. We're gonna listen to me for a minute, and then you'll get out of there,
sir.
right? Or we can listen to you. We'll be here the rest of the day. Make sense?
Yeah.
All right. All right. We'll call both cases at the same time. You got case 24045533 and 24058126, State of Michigan versus Giovanni Alvante Carson, counsel.
For the record, I'm sorry, Ms. Douglas. I'm sorry.
Okay. Jennifer Douglas for the people, P17748.
And now for the record, Your Honor, Janice Stevenson appearing on behalf of Giovanni Carson, who stands mute, waives the reading of the information. We ask the plea of not guilty be entered on his behalf. Carson has been advised of his rights, Your Honor.
Thank you. Court will enter not guilty pleas in both cases. As to bond, please.
Your Honor, on the fingerprint refusal case, if people have no objection for a personal bond, we would just ask that a condition of release be fingerprinting if he hasn't been fingerprinted yet. Your Honor, on the R&O, we are actually going to ask for a high personal bond, 100,000 personal, but we would also actually ask for time curfew. We have
100,000
some
personal.
concerns. I know he's charged with RNO, but he's charged with resisting the police during a lawful arrest, with that arrest being for based on what the DTE worker said happened, as far as Mr. Carson threatening him and pulling out a knife and to threaten him. There was a knife found on him. Well, he's not charged with the knife. We're asking the court to look at this in totality. I know the court's had a chance to look at the report and see that officers did take Mr. Carson to the hospital, try to make sure he was okay, and the people had some concerns about Mr. Carson being okay and people around him being okay. And
can we just stop for a second and thank her for the awesome microphone?
the thing about cones, this is supposed to have come out of moving some cones. It being summer, there's going to be a lot of cones and Mr. Carson's going to be encountering on the road. And we have concerns about this situation repeating itself, Your Honor. That's why we're asking for Tether and a curfew that will allow Mr. Carson to go to work. If he needs to go to the doctor, he could go to the doctor. But we do have a concern about danger to the public here, as being on the road with there being cones is something that's going to be going on for months. So that's why we are asking for Tether and a curfew and a high person.
I'm a grown man. At the same time, that's having a good situation. Y'all know I have an ID. Y'all lied to say I was gonna help me. Y'all swoop me up off the streets on some.
Mr. Carson, can I say something real quick first?
Yes, ma'am.
Okay, thank you, sir. I appreciate that. Your Honor, we would concur in the request for the personal bond for each of the matters. They're both non-assaultive. And looking at the charge with which that Mr. Carson is actually facing, it looks like he just made his body dead weight, Your Honor. He didn't engage in any assaultive behavior. I don't know that having a GPS tether would, be, if that in and of itself would stop Mr. Carson from touching any cones that he's not supposed to be touching. So I think that, as Mr. Carson has indicated, he's an adult. He understands, he knows how to listen to the court. He doesn't have any criminal convictions that I'm aware of. The court has made him aware of the other matters that he has to go to court for. We do have an address for Mr. Carson. He would be given discharge paperwork if he's released from custody. And I think he knows how to read that and be where he's supposed to be when he's supposed to be there. I don't think that Mr. Carson wants to have any more of this kind of interaction with the police. There's, nothing that he's been convicted of to demonstrate that he's had a problem. This kind of situation is going to continue. Mr. Carson probably does need to address some other issues. But again, he did not engage in any assaultive behavior. So I am asking the court to release Mr. Carson on personal bond without the GPS tether, so that he doesn't have to be transported from the Detroit Detention Center over to the county to get to wait in line for several days before the tether is even put on. That time in jail would probably be the only time that he would spend in jail on these charges.
I ate them.
And I'd ask the court not to put a tether on Mr. Carson.
I ate them
I think he knows how to be where he's supposed to be. I think he knows how to stay away from places he's supposed to stay away from.
Understood.
Okay. Is your client employed?
He's looking for work at this time, Your Honor.
Okay. All right. As to the misdemeanor case, conditional bond is he must be fingerprinted prior to release. Court will set bond at $1,000 personal. Next court date in that case is a pretrial August 14 in front of Judge Bryant here in 36th District Court. As to the felony case.
Yes, that's what he said. He's going straight to Bryant and Jones.
Is not to possess a firearm, a knife, or any other dangerous weapon as a condition of bond. Bond will be $10,000 personal. Next court date is July 16, probable cause conference, July 23, preliminary exam, both in front of Judge Sabree here in 36th District. Thank you, sir. You can step aside.
Thank you, Your Honor.
Thank you, Your Honor.
Look, so I can't have no money. I'm trying to get my CPL.
Got personal bond, Mr. Carson. Go ahead and go with the officers, okay?
So for
Thank
the
you.
misdemeanors, he's going to Bryant, and for the felony, he's going to Sudbury. Best of luck, dude. Best of luck with your harassment. Nope, I don't want to do that yet. Okay. We're going to a little bit of an attitude, guys. We got a little bit of an attitude going on here.
I have an announcement of appearances, please.
This is
May it
in.
please the court, Don Washington.
Oh, don't remember. I don't remember where this is. I do want to say Texas, but I could be so wrong. He doesn't. It's like Judge Bree or Gee, or I don't think it says it there, does it? Oh, I can't remember where this is. Sorry, it's not coming to me.
Singer appears via Zoom. She's off camera. I don't have her on, but she is here if you need to see her via Zoom and by and through Attorney Greg Schwartz, also via Zoom.
Okay, yes.
Okay. Thank you.
Joshua Cunningham via Zoom.
Okay. Mr. Cunningham, you're appearing here today pro se, representing yourself.
Correct.
And that is your choice to be without an attorney today. And you've had the opportunity to hire one if you so desired.
Correct.
Okay. And Mr. Schwartz.
Well, Your Honor, I wasn't sure why this was set, but I think we probably just need the writ. I see an issue with that we need to get reissued. And so we'll get that sent over to the Sheriff's Department, but I think that's the only thing where we really stand at this point. So I don't know that there's anything else we need from the court at this point.
The court had signed the order of execution on June 30th, and you had filed the writ. Are you making corrections to it?
Yes.
Okay.
We need a command for the Sheriff's Department to take their action, and that's not in there, I noticed.
Thank you, Kelly. Thank you.
So we'll get that sent over today, and I don't know that there's any hearing that needs to be held on that. I think we just need to have the new writ issued and then have them serve it.
I'm
Mr. Cunningham.
I don't understand this. I mean, we made an agreement at the end of May, and I'm paying it as agreed upon. I'm gonna be right honest with you. The camper is no longer. It was damaged in May in a storm, and the insurance company has taken it. I'm waiting on that settlement. They will pay the loan off at the bank. Whatever is above and beyond that loan, I have no issue with putting towards this back child support. All guns for that aspect have been sold to make sure that I could pay this.
True.
And the snowmobile has a loan on it at the bank. So I guess I don't understand this. I mean, when we were in agreement and I'm paying it as agreed upon.
There's an amount to be paid, but you understand you also have, it is a judgment against you.
Correct. And we agreed at the end of May to
on the judgment.
But we agreed at the end of May to a set amount each month.
That's on your payments, but when you owe a obligation like this, they can also do a writ of execution to take unprotected assets and have them sold to satisfy the judgment. That's a choice they make.
Okay, well,
now
like
you can speak to Mr. Schwartz about that if you two would like to discuss
I have tried to talk to Mr. Schwartz. He will not return phone calls. Every time I've stopped in his office, he's not there or busy. And I mean, I've tried to speak with the man, and it's nearly impossible.
All right. Mr. Schwartz, would you like to speak with Mr. Cunningham?
Yeah, I don't have a problem. And he has called me a couple of times where I didn't return his call, but the last time he called me, I did. And
I have no idea.
Jess, why don't you put Mr. Schwartz and Mr. Cunningham in a breakout room, and they can talk about the property and
Wichita.
see whether we need to have a sheriff seize it and sell it.
Judge, he should be coming back over here, I thought.
Okay.
There he is.
Nobody's in charge of that.
Josh, are you there? We can't see you.
It takes a moment to hook in.
I can't, how do I get back? I'm trying to get back to the main screen so I can see everybody.
You're back on, Mr. Cunningham.
Okay.
Can you see us?
No, I cannot.
Okay, well, we can see you and we can hear you.
Okay.
Okay, and Mr. Schwartz is back also.
Okay.
Okay, were you able to speak in the breakout room?
Yes, we were.
Okay. Mr. Schwartz.
Your Honor, I don't know that we came up, we don't really have an agreement other than he continues to pay. I guess it is somewhat, but he's going to continue to pay the $500 that he's paying, which I don't think really is affected by today. But he said, like he said earlier, he's going to apply whatever excess he's got from the camper. And I need to talk with my client if she wants to pursue. He told us that there's no value in any of the others except for maybe the pickup, but and he sold everything else. But so we'll have to decide whether she wants to take any action based on the values and whether it's worth any money or not. But I don't know that there's anything to journalize or to formalize out of this. I don't think there is. So,
Okay. And just so Mr. Cunningham, you understand, the $500 a month is how you're purging yourself of contempt for not pay. Okay.
Okay.
That's for the contempt of court. But the obligation you owe of $37,000 in past child support can be collected like any other judgment. And so they can do debtor's exams. They can seek to sell non-exempt property, and that's what they're doing here, because you've got that obligation that's still owed. The $500 a month is how you're purging yourself of contempt of court for failing to pay. But that doesn't mean that they cannot go after you to collect that debt that you owe. Okay?
Okay.
Okay. So Mr. Schwartz will decide if he wants to pursue a writ of execution on any other assets. It would probably be to your benefit, Mr. Cunningham, if you make sure that Mr. Schwartz has a good way to contact you, such as an email.
Yeah, he should have all that.
And that might be faster and easier than citing you in court again or bringing other motions. Okay.
Okay.
But the obligation is still there until it gets paid off.
Oh, I understand that. Yeah.
Okay. Anything further, Mr. Schwartz?
no, Your Honor.
Anything further, Mr. Cunningham?
No, sir.
Okay. Mr. Schwartz, let us know if we need a further hearing.
All right. Thank you, Your Honor.
Thank you all.
But
I'm muted. So I'm pretty sure it was Masioc that called that hearing, but for nothing, we don't know. They don't know why, but dude owes a lot in child support. Sure does, and they're going after him for it. They're going after him. They want him to sell all of his stuff. He sold all of his guns. Now he's got to sell his snowmobiles and his camper. Legal, do you have a Russian accent? I'm thinking legal. has a Russian accent, just like, what was that guy's name? Doesn't matter. You know. Yeah. Yeah, I left my mute on. That happens. Muting happens. It's better I leave my mute on by accident than I leave it unmuted by accident every day of the week. There's Fozzie. Fozzie, you're supposed to cover that up. You're supposed to make excuses or something. You're not supposed to call me out. See, look, she covered it up. Okay, okay. We're never gonna get to this per se, and it's so good, but we're not there yet. Do I have the same clip twice? I think I do. It's just named two different things. Hold on. Let's see if we already saw this today. Yep, that would
Good
be
morning,
me.
sir. What's your name, please?
Shush you. We already heard you. All right, we did it. We got through all the clips except for one. And it's good. I like it. I like this clip. Nothing crazy happens in it, but it's the aftermath of the crazy. We missed the crazy. Now we get the aftermath. Here we go.
2308 F6 1006, State of Indiana versus Andrew Rogers. Mr. Rogers, raise your right hand to be sworn. Do you swear or affirm under the pains and penalties of perjury your testimony you provide to this court will be the truth, and the truth and nothing but the truth, so help you God?
Yes.
Thank you. Go ahead, next seat, please. And please tell me your full name.
Right.
Thank you. The court shows that the defendant appears in person and also with Attorney Bridget Faulkner. The state of Indiana appears by DPA Anna Ridge. And this is a continuation of a hearing that we started last week. All right, so Mr. Rogers, I'm hoping to start things.
I don't think she's going to make a big deal out of the hat, only because she's already dealt with him enough. She's had enough of him.
Off differently than what we had last week. Mr. Rogers, you had indicated last week to the court that you wish to represent yourself. Is that correct?
Yes.
Mr. Rogers, that discussion rapidly deteriorated, and we did not get through all of the dialogue that I had to get through with you to make sure you understood the consequences of waiving the right to have an attorney represent you. In fact, the court did end up conducting a contempt hearing with you. The court did find you in contempt. However, I suspended that contempt finding depending upon how things go today. So hopefully things go better today. So Mr. Rogers, again, I'm required to ask you these questions before I can allow you to waive the assistance of counsel and go forward in representing yourself. You understand that? All right, so again, Mr. Rogers, do you still wish to represent yourself in this case? And Mr. Rogers, we talked a little bit about your educational background last week. I recall that you indicated that you did not have any formal training. However, you had informal legal training. Is that what you had stated?
The problem is in this courtroom. See where her microphone is? Right here? We can hear her when she talks fine. But this attorney, I think, put the microphone way over here, I think. I'm only guessing that that's the microphone. So we can't hear him. However, the judge does a really good job of repeating back to him everything he says to her, sort of.
Mr. Rogers, one of the concerns that I had last week was you indicated that it was going to be your intention when we went to trial that during your opening statements, you were going to play some type of audio clip for the jury.
Super Tramp.
One of the things that you said? Okay. And I told you that that was not going to be possible at that stage in the trial. And I was trying to express to you my concern about going forward without the assistance of an attorney. So, Mr. Rogers, one of the questions that I asked you previously was if you knew how to get an exhibit admitted into evidence at trial. And my recollection was you told me you would figure it out by that point in time. Have you done any research as to how you would do that?
Yes, I'm looking at that.
Okay, but you don't presently know how to do that. I'm sorry, can you just speak up a little bit? Okay, do you understand that Ms. Faulkner is a very seasoned trial attorney? I've tried cases against her. She's won against me. I've seen her in court as a judicial officer, try cases. Do you understand that she currently knows how to introduce an exhibit into evidence? Okay, so do you understand that that would be a disadvantage to you at this point in time, not knowing how to introduce an exhibit into evidence? And she already knows how to do that and has done that.
Yes, concerns and stuff, that's why.
Okay, go ahead, what are those concerns?
Representation, this is my first time working with a public attorney. Right, like you should.
Okay, Mr. Rogers, my understanding of one of the concerns that you have is that Ms. Faulkner has not filed a motion to dismiss on your behalf. Was that one of your concerns? Okay. And did she explain to you, Mr. Rogers, that under Indiana law, there are very limited circumstances that would allow her to file a motion to dismiss?
She made aware of that.
Okay. Ms. Faulkner, would you agree that you've made him aware of the very limited circumstances that you would have to file a motion to dismiss on his behalf?
I have here explained that when it's a factual dispute, that's how we go trials.
And that's exactly right. So, Mr. Rogers, there are only a couple of, I'm thinking double jeopardy issues and criminal rule 4 issues are the two that come to mind that would provide her with a legal basis for filing a motion to dismiss. If there's a disagreement about the facts of the case, that would not be a proper basis for a motion to dismiss. In fact, if you represent yourself in this case and you file a motion to dismiss, just saying that you disagree on the facts,
Taser.
you understand that if that's what the issue is, I will not grant that motion to dismiss.
Taser.
Because I would have no legal basis under Indiana law to do that. The way to handle that would be to go to trial. You understand that, sir? Neither Ms. Faulkner nor the court can make the state of Indiana change how they've charged this case. If they believe they have the evidence to support the charges that have been filed, it is within their right to proceed to trial on this case. You understand that? Okay. So what other concerns do you have?
It's a lot. She heard all the evidence and the money and stuff like that. And I feel like the cards are stacked against me, and I feel like I can represent myself. Right now, it's good as her, but the truth of it is never found that. I never told her that. That's not the truth.
Okay. And Ms. Faulkner has tried many cases. And I know that depending upon the particular set of facts and circumstances, she may or may not advise her clients whether or not they should testify and tell their own story. But ultimately, it would be your call. And if she was still representing you in this case, and if you wanted to take the witness stand and tell your side of the story, she's not going to stop you from doing that. You understand that? Okay, but there is a way to do that. And if you represented yourself, I'm going to limit the way that you do that. Because there's a procedure, there's a way that we conduct the trial, and you can't just, for lack of a better term, just stand up and blurt out whatever it is that you want to say. There's a mechanism and a process for making that happen. You understand that? Do you understand, Mr. Rogers, that you do have the right to remain silent? And if ultimately you choose not to testify, that's certainly your right under the Constitution of the United States, as well as the Indiana Constitution, to remain silent. And that Ms. Faulkner, again, as a very seasoned trial attorney, she would represent your interests at that trial without you waiving that right to remain silent. Do you understand that? Mr. Rogers, if you decide to represent yourself, you are almost certainly waiving that right to remain silent. Do you understand that? You understand that that could be problematic for you? And Mr. Rogers, I'd expressed concern last week when you appeared via telephone and with how quickly our conversation went downhill, that if that happens in front of the jury, it's not going to go well for you. Do you understand that?
We would appreciate it very much.
All right, so Mr. Rogers, do you still wish to represent yourself in this case?
Say yes. Say yes. Just say yes.
Of course.
I see the attorney talking, but it looks like, okay, now she's doing more of the talking. It looks like he was doing most of the talking, which is useless in this situation. I could do that. I could. We probably missed a whole bunch of stuff talking in chat. And then this time we'll see it. All right. Decision time. Let's go. Come on. Do, 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 do.
Okay. And Mr. Rogers, one thing that I also want to make clear to you, because I think that you had said last week during our discussion that if Ms. Faulkner wanted to stay on, I think you said as a lay person in your case and help you, that she could.
This is really interesting. Listen to this part. This part's really good. If he wants her to represent him.
It is not this court's practice to appoint standby counsel. Either she's in or she's out, period. You understand that's how that will work. You'll either be completely alone without the assistance of counsel, or you will be completely represented by counsel. There's no right to what we call hybrid representation.
Me too.
Okay, how do you wish to proceed? Do you want to have the public defender or not?
No standby counsel. They don't allow standby counsel. Well, she doesn't. I don't know if all of Indiana is like this, but you know, sometimes they give them standby counsel, so the counsel just has to stand there and look pretty while they ruin their whole case. He doesn't get a lawyer to do that for him.
Okay, so I think because of that, Mr. Rogers, because you're not sure what you want to do, I'm not going to withdraw the appearance of the public defender's office. With the understanding you have to cooperate with Ms. Faulkner. I'm not saying you have to like everything she tells you. You can agree to disagree, but you have to be respectful. You understand that? You can't scream at her. You can't expect that she has some type of a magic wand and do things on your behalf because, again, the state is in control of the charges here. And Ms. Faulkner can only do so much up to, we just need to go to trial and determine whether or not a jury decides whether or not the state has met their burden. You understand that? Ms. Faulkner, would it be appropriate from your perspective to go ahead and set a trial date? Okay. Just to make sure that we preserve that right, Mr.
Every day about an hour and 11 minutes before right now, which is 4:30 my time, Eastern Standard Time.
Rogers, go ahead and get a trial date in place and you start working with Ms. Faulkner regarding any information that you wish to present. Is that what you want to do? Okay. So just looking ahead at my next available date and just to build in enough time for you to work with your client, I am looking at October 8th, Ms. Faulkner.
Should be fine.
Is that date acceptable to the state?
It is.
All right.
My boss says I can start anytime I want, but my supervisor, he's rude.
At the request of the defendant, the court will set this cause of action for jury trial on October 8, 2024 at 8:30 a.m. The court will set aside 2 days. Let's just go ahead and do 3 days to be on the safe side. 3 days to try the matters at issue. I'm also going to set a little bit of an earlier pretrial conference date just to see how things are going. And let's do that maybe towards the end of August. How about August 20, that date? I can either do August 19th, Ms. Faulkner, or we can do Tuesday, the day after Labor Day, September 3rd. Do you have a preference?
Whatever is best.
5:42 right now.
Why don't we do August 19th? Is that date acceptable to the state?
It is.
All right, the court will set a final pretrial conference on August 19, 2024 at 8:30 a.m. Mr. Rogers, do you need to appear at that final pretrial conference on August 19th at 8:30 a.m.? We've had a much better conversation today. I think it would be helpful if you're here in person at that time, Mr. Rogers. Do you understand that you
Don't you know?
Here in person on that date? I think that's what she wrote down for you, yes. Mr. Rogers, do you also acknowledge or understand that I've set your case for jury trial on October 8, 2024 at 8:30 a.m.? Do you understand that if we don't see or hear from you between now and then, and if your case proceeds to trial on that date, and if you are voluntarily absent, we're going to go forward without you? Do you understand that? Mr. Rogers, please cooperate with Ms. Faulkner. I can assure you that she is a professional. She's willing to move past this. She's also a very seasoned trial attorney. You really should listen to the advice that she provides you.
He is not going
Understood?
to.
Okay, so I'm not going to have you taken into custody today on that contempt. However, we are going to address it again when we come back for the final pretrial conference as an additional incentive to help you cooperate in your best interest with your attorney. Understood? All right, anything further, Ms. Faulkner? Yeah.
Just needed August 19th, and you just acknowledged your jury trial in October.
Yeah, okay. That's why I got you about litigants there.
There's 2.
You have a final pretrial conference in August, and then your trial is in October. So the final pretrial conference is just to make sure we are still going to trial and make sure there are no other issues that we need to address. Anything further from the state? Nothing from the state. Okay, and he needs to schedule an appointment with you, I assume, Ms. Faulkner. Do you know where the public defender's office is located? Go to the public defender's office before you leave and schedule an appointment. Okay, thank you. That will conclude the proceedings.
Roberts.
Carolyn, I like your boss as much as I like my boss. It has to be, right? Because I don't know. I don't know if she just doesn't want to start trouble with by telling him to take that thing off, or if it's for religious purposes. Could be. Who knows? I don't know. I do know I'm going to catch her. So she has so he got contempt of court last time they were together. He called in on Zoom and started arguing with everybody. He got contempt of court, and he had a contempt of court hearing that we didn't see. We didn't see either of those. So she brought that contempt of court into this hearing, and she's like, you know, I'm not going to do anything about that now. Let's go. Let's set a date for the next hearing. If you don't behave, contempt of court is going through. Now she's bringing it forward again. She's like, I'm not going to do anything with that contempt of court, but I'm bringing it with me. So if you don't behave, you're getting it, buddy. You are getting it. Oh, no, too. Guys, we should start a GoFundMe because eggs are freaking expensive. We, that's like $2,000 right there. That's a lot of money. 2 eggs are broken. So that's the clips that I have for today. So if you're here to watch videos, have a great day. It's Tuesday. So have a great Tuesday. There's no courts. There's no Fleischer today. Courts are still down, so I've heard. I mean, I'm still gonna check because, you know, I don't know, obsessive compulsive disorder. I don't know. I'm still gonna check because you never know. But I don't think I'm gonna have Fleischer tomorrow. Unless I buy a new box of crayons and fake it. You guys would never know. Never. Fletcher, it's too late. Dude, the beer has been drinking. The beer has been drinking when that guy was really high. Sarah, you have fun. Oh no. You got dented Cokes because they dropped it. Thanks, Chris. I appreciate it. Caddy didn't think it was a good stream. She had to go because of the echo in her ears. Jay, I hope you have a good day too. Fozzie, I'm so glad you have electricity. I really wish Irish would come on, and Irish Dublin, so we know they're okay. You guys need to move somewhere safer. So I don't get stressed out like this. I got gray hair. You guys owe me a box of hair dye for this hurricane. Well, I wonder what hot beer tastes like. That's my favorite. Like, okay. Every Friday after my divorce, every Friday night I went out to the American Legion, and they had a live band, and I had a lot of my friends there, and we would have a blast. We would have so much fun laughing and joking and dancing, a lot of dancing. So I would buy a pitcher of beer when I first got in. As soon as I got in, I would walk up, and I don't even know what beer they gave me. You know, whatever was on tap, I just got a pitcher. They would ask me what I wanted. Just give me a pitcher of beer. Take my pitcher of beer for $6 over to the table and drink some of it while I was eating as fast as I could, and the band started. And then we were on the dance floor all night, dancing all night. And by the time I got back to the table, my beer was warm and flat, really, really flat. But it tasted so good after after dancing and breaks in between when the band takes a break. It was so good. We were so thirsty, and there was that flat beer. No one else got a pitcher. They all got like 1 or 2 beers, but not me. Not me. I was 1 or 2 pitchers. I was pitchers because it's such a waste of time getting a glass of beer. It just is. I don't care what anybody says. If you're going out to enjoy yourself and have fun, then 1 beer is not going to be enough. And don't worry, I never drove. I don't drive when I drink. I never drive when I drink. I have plenty of kids for that. I mean, I had them for a reason, right? So that I could drink. They make me drink most of the time. They force me to it. They practically hold my mouth open. No, but you're hot and you're sweaty and you're laughing and you're having fun. Flat beer tastes good then. Yeah, pitchers are cheaper. And they my pitchers of beer never got drugged. Couldn't remember the word. I know there's that other word. What type of drug do you put in? Roofied. I never got roofied. It was fine. I was the American Legion. Yeah, kids definitely do that. It's not though. You know, in other countries, they on purpose drink beer flat. Not all beer, but some beers you just don't drink ice cold. You just don't. You drink it room temperature. Yeah, they, yes, they do hope. Like that guy. That guy must have 7 kids. That guy we watched earlier, that's why he was baked. He had 7 kids, 8 kids. He has 13 kids at home and he needed a break. And he took a break this morning right before court by eating one of the brownies that were out by accident. And that's it. That's what happened. Me and Hope figured it out. I don't know why you guys didn't. It was pretty obvious. A pitcher was my glass. See, Sally understands. Ah, uh, I don't know. I don't know, but I want to quack. Did you guys ever hear about those quacks? Horsefish told me about quacks. I'm going to show you a beer. I'm going to show you a beer. I'm going to show you a beer, guys. Hold on. And now I want it. Now I just want, I don't just, oops, I typed in quack, like Google's going to know what I'm talking about. Quack beer. That's better. So apparently, that's the quack beer. All right. It's Belgian. Okay. And it comes in this wooden thing with this little bubble on the bottom. All right. And if you're a noob and you try to drink this quack beer, you get it down so far, but once the air hits this bubble, if you're drinking it real fast, um, it'll like splash up in your face. So people in Belgium always get tourists these quack beers and then watch and wait. But ever since I heard of that, this is the only way I want to drink beer now is through a quack. I don't know if you call that quack. The beer is called quack. I don't know what you call this. Beer glass with stand. I think it needs a better name than that. That's a boring name for something so delightful to bring ages and ages of fun to everyone around. I could get it from the Dutch expat shop. I can get it on Amazon, but I really don't think. Oh, okay. I'll look for a video. I just don't know if Amazon's going to give me the real stuff. Probably not. I'm looking for a video. Oh, I could spell it right. That might help. No, I don't care about how you pour it. I want to see someone drinking it for the first time. I don't think this is what we want, guys.
Days, or rather say BBD. With this channel, I would like to introduce you to the Belgian beer market. Today, we are visiting brewery Osteels. At Osteels, we have the beer Karameliet, Kwak, and Deus.
Kwak was our first beer, so it's made from barley, but it's an amber-colored beer. It's also 8.5%.
I just want to see if he's going to drink it.
What is so special on it? It's own beer, special glass, because with a lot of foam, you will see that the foam will come onto top of the glass.
Thank you for watching this video. If you want to discover more about Belgium,
I love that accent too. Legal, is that what you sound like? Just want to know. Just want to know if legal has a Georgia accent or a Russian accent, like that guy earlier, who is definitely Russian. Definitely Russian. I looked it up. I didn't look it up, but in my head, I looked it up. That's too much booty. I would never serve you that. Never, never, never in a million years. Well, then our beers are kind of expensive, though. So if I give everybody a lot, that's like robbery. Okay. I didn't find anything. I typed that in, pranking someone with cracked beer. Fake beer, shotgun beer, pranking a cop with fake beer. I see this, but it doesn't, it's probably
Hello.
not.
So I bet you're all wondering why I've got this strange looking glass in my hands. Shall we find out what beer you drink from this glass and why it's particularly this shape?
I just want to see him. He's lifting the whole stand up. I'm sure you don't do that. Right? You take the beer out of the stand, right?
It's very drinkable. It's not like a lot of these strong beers.
He doesn't drink it till the end and gets splashed. Everybody's going to start drinking beer now. I am. Because I'm off work now. This is it. I'm off work. I have, whoo, oh my gosh, it's only 6 o'clock. I have 2 hours until court's open. I could get a lot of work done, or I could drink some beer. I'm sorry, Kelly. I will drink for you. I don't know what to do. I do know what I'm going to do. I very much know what I'm going to do. All right, guys, I'm going to head into Discord if you guys want to talk, or you don't have to. You just don't. I don't want you to. If you see me all alone in Discord, you don't have to feel like you have to go down there. I'm just there if anybody wants to talk or not. Or type in chat. You can always type in chat. You can also come in and listen. If you don't want to talk, you can still come in and listen. We have some fantastic accents. I mean, for real. Not me. I don't have an accent. I do remember when I first started streaming, somebody said, wow, do you live near Philadelphia? You have that accent. And I'm not, I mean, I'm within 2 hours of Philadelphia, probably an hour and a half. I'm like right within driving distance, but I certainly don't have a Philly accent. And I don't think I have an accent. I think I just have a general American accent, like a general American accent. So I'm wondering, I've always wondered what it was that made them think I was near Philly. They were right, but what do I say that makes them think I'm near Philly? There's Discord, by the way, if you want to go into Discord. If you have any issues getting into Discord, let me know. Send me a message in Discord and I'll help you. I'm joking. All right, guys, I will see you. I will see you in Discord, and then I'll see you tomorrow. Bye, guys. Thank you so much for coming out. I appreciate it. Mods, thank you so much for all your hard work. Thank you. Bye, guys.